Good morning, everyone, and welcome to today's San Francisco Interfaith Council's weekly online briefing for faith leaders, centering around COVID-19 and houses of worship in the United States Constitution. Hosted by the San Francisco Interfaith Council and supported by the Joint Information Center of the San Francisco COVID Command Center. Some housekeeping for today. Audio, video, and chat will be monitored and recorded for record keeping, training, and quality assurance. By default, all participants will be muted and video turned off to minimize distractions. To submit a question or comment, select the chat button at the bottom of your screen and send a message to Q&A. They will be shared with the speakers after the meeting for response. Thank you. Due to widespread COVID-19 infection rates, the state has now moved San Francisco into the most restrictive tier purple. In accordance with the state order, there are many restrictions on indoor activities, including the temporary closure of indoor worship services, gyms, movie theaters, museums, and indoor retail capacity is limited to 25%. Additionally, San Franciscans must follow the state's limited stay-at-home order, which includes that you can go outside on your own or with people that you live with. You can go to an essential job. Avoid being around people from outside your household between 10 p.m. and 5 a.m. You can still get food takeout after 10 p.m. and go to grocery stores and pharmacies. Our actions now will shape how San Francisco emerges from this pandemic. Together, we are resilient. Learn more at sf.gov/limitedstayhome. Get tested, San Francisco. You can save lives and stop the spread of COVID-19 by getting tested through your healthcare provider. If you have symptoms or have been exposed to COVID-19 but don't have health insurance or can't get tested through your provider, visit sf.gov/gettestedsf or call 311 for information on getting tested at a city-run testing location. At this time, I would like to hand the floor over to the Executive Director of the San Francisco Interfaith Council, Michael Pappas. Michael, the floor is yours.
Thank you, Elisa, and thank you to our wonderful team at the COVID Command Center's Joint Information Center Virtual Outreach Team. This will be our last program for 2020, and we are grateful for the support that you have offered. Good morning, I'm Michael Pappas, and on behalf of the San Francisco Interfaith Council, I want to welcome you to this morning's online briefing for faith leaders. In times of crisis, governments are called upon to take extraordinary measures to protect those entrusted to their care. Tensions emerge when those measures come into conflict with constitutional safeguards. This week's online briefing for faith leaders, hosted by the San Francisco Interfaith Council and supported by the COVID Command Center's Joint Information Center Virtual Outreach Team, welcomes University of San Francisco Law School Assistant Professor Luke Boso, who will provide an overview of the Supreme Court's free exercise jurisprudence, the current state of statutory religious freedom law in California, and the future direction of this legal area as it relates to COVID-related restrictions. Regarding the on-point constitutional law, this discussion will be divided into three components. First, the law as it stood prior to the court's famous Smith ruling in 1990. Second, the law following Smith until this year. And third, where the law is heading with the addition of Amy Coney Barrett on the Supreme Court. Also included in this presentation will be a discussion of the court's two most recent decisions on COVID restrictions as they relate to in-person religious services, both of which were issued just within this last month. And now, with further ado, it is my distinct pleasure and privilege to welcome the chairman of the board of the San Francisco Interfaith Council, friend and colleague, Kaushik Roy.
Thank you, Michael, so much. And on behalf of the board of directors, everyone who's joining us, I just want to extend a very warm and sincere welcome to all of you this morning. I forgot to do this last week, so I want to start off by just acknowledging our amazing staff of two. As this year mercifully comes to a close, I believe this is the 31st, possibly even the 32nd, one of these weekly meetings we've had. We used to do something like this once a month, and because of the pandemic, we've now been doing it weekly, and that's just only one of the many new responsibilities Michael and Cynthia have taken on, given what has been happening this year. So to Michael Pappas and Cynthia Zambucas, please know not just the board, but the community recognizes how special you both are and how much you do. So thank you to the two of you. I happened to notice this morning that today's date marks 9 months since Mayor Breed first announced the initial shelter in place. And as I mentioned, this year is mercifully coming to a close, but we also have to acknowledge, at least at the start of 2021, it will also be clouded with a lot of uncertainty. And I want to actually acknowledge and thank all of you in the community for your resilience during all this time. I was in another conversation this week and noted that when the historians have to write about this year, we have an idea of some of the things they will definitely write about, including the political absurdities of 2020, the ravages of COVID. But the one thing I don't know if they will write about, and I hope they do, is the immense courage and resolve and resilience and compassion of everyday people who just stepped up in any way they could, had to take on so many challenges and still tried to be there for one another. And so I hope we all realize that our baseline right now is trauma, and we are continuing to move forward under the most difficult of circumstances. For those of you who are joining us for the first time, there is an interfaith statement that we like to read at the beginning of each interfaith gathering or meeting. It's a way to take a moment to center ourselves and remind ourselves why we are all gathering. So I'll read that now and we'll continue with the program. This is an interfaith community. Whatever our individual belief, it can be freely expressed here with no apologies. If we are invited to offer a prayer in this setting, it should be offered according to the tradition with which we identify. If we are invited to speak on a subject from the perspective of our tradition, we are free to do so without fear of offending those who come from another tradition. We come together as people of faith to learn from each other that we might better understand the multiplicity of faith traditions in our city and in our world. Have a safe and happy holiday season, everyone. Thank you.
Kushik, thank you for your leadership on this board, as well as for the visionary leadership you offer as Executive Director of Shanti, the Shanti Project, which is making a difference in so many people's lives. God bless you. I have been blessed to know Rita Simmel, the founder and past chair of the San Francisco Interfaith Council for 17 years. She is the matriarch of interfaith in San Francisco, and also a staunch and ardent supporter of the Constitution and its many provisions. And so on this last day of Hanukkah, I thought it would be appropriate, considering the theme, if we asked Rita to lead us in this morning's reflective and meditative moment. Rita, the floor is yours.
Thank you, Michael. It's a privilege. I'm thinking about what I was going to say this morning. It occurred to me that we're celebrating Hanukkah, Kwanzaa, and Christmas, and many other faiths. And all of them have at the base the one thing that we Jews call tikkun olam, repair the world. That's our job as citizens, as people of faith, as members of the community, repair the world. As we look around us this morning, we see a very shattered and destructive world, and it is our job to make it better. And we can make it better. I'm the perennial optimist, and I've always felt that anything is possible if people of goodwill will get together and work together. And that's what's at the base of the San Francisco Interfaith Council. And that's what we've been doing for all these years. I like to think we've been making a difference. And with all of your help, we will continue to make a difference. So I wish all of you, whatever you're celebrating, all good health, good wishes, and let's hope that 2021 is a better year for us all. Thank you.
Amen. Thank you, Rita. And we know that you're going to have to depart a little early because you serve as a commissioner on the Human Services Agency Commission. There's never been a time when HSA has needed your visionary wisdom. So please, by all means, when you need to leave, please do. Okay?
Thank you very much. And all good wishes to everyone for 2021.
The constituency of the San Francisco Interfaith Council is broad and vast. We count as our constituents the 800 communities of faith and religious institutions in San Francisco, not just our congregations, but also our judicatories, our faith-based social services agencies, our healthcare institutions with religious affiliation, but also our academic institutions. And the University of San Francisco has been an incredible partner in all that we have done. And we are very fortunate to have with us today Luke Boso, who is an assistant professor at the University of San Francisco Law School. His impressive resume was included in the program announcement, and I would direct you to take a look at that at some point. But he is here today to talk about the elephant in the room. The one subject that we have waited until now because it seems to be almost the most timely discussion to be having. Luke, we thank you for being with us, and the floor is yours, my friend.
Thank you very much for that warm introduction. And hello, everyone. It is truly an honor and a privilege for me to be here with you all this morning. I think it goes without saying that this has been a tough year for the United States, for the country, the humanity writ large. So it's nice to gather amongst people and talk about something that I'm very interested in, which is religious liberty and the Constitution. One of the most, I think, dynamic and fast developing areas of constitutional law right now. So give me 1 second while I transition to share my screen with you. Okay, so my comments today will proceed in roughly 4 parts before we open up the discussion just for questions and comments. So the first thing I want to do is get some baseline foundational principles on the table. So what does religion mean? What does religious liberty mean as a legal concept? What does the Constitution have to say about these things? Second, I'm just going to briefly walk you through some of the history on religious liberty prior to 1990. And this history is important because it looks increasingly like the Supreme Court is on its way back to applying some of these earlier principles with respect to religious liberty. And then third, I'm going to talk about the court's most famous religious liberty case, Employment Division versus Smith, which was decided in 1990, which set the legal standard for religious liberty claims since 1990 until still today, although there are some caveats. And then finally, I'll talk about where we are now. So what does Amy Coney Barrett's elevation to the Supreme Court mean for religious liberty going forward? And how has the Supreme Court begun to address some of these executive orders and other governmental actions that affect religious institutions and services during the time of COVID? And then we can open it up for questions from there. So first things first, the basics. So what does religion mean from a legal perspective? What does the First Amendment have to say about this? So a good place to start is just with the text of the First Amendment itself. The relevant text here is pretty short. It just says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so within that text, we have 2 important constitutional clauses, the Free Exercise Clause and the Establishment Clause. Notice that this is pretty bare bones. So a lot of the work in constitutional law is interpretation, and there are different methods of interpretation here. In terms of what these clauses do, so the Free Exercise Clause speaks more directly to individual liberty. And the Supreme Court has held that this religious liberty extends both to freedom of thought and belief, which is absolute, the court has said, and in some cases, the freedom to engage in or abstain from engaging in certain kinds of conduct. The reason that not all conduct is protected under the free exercise clause is because the Supreme Court has said that this would sort of impede our ability to function as a society governed by law rather than men, and to make sort of coherent decision making that applies kind of broadly across the board. The Establishment Clause is less about individual liberty and more about restraining the government. The way that the Supreme Court has interpreted the Establishment Clause most commonly is that the government has to avoid acting with either the primary purpose or effect of advancing or inhibiting religion. And there are some other interpretations of establishment, but this is still the governing test. And in terms of how these two clauses work together, the Supreme Court has repeatedly explained, for good reason, that they're in tension with each other. So if you think about why, for example, anytime that the government affirmatively acts to protect individual liberty, there's a risk that its primary purpose or effect might be seen as advancing or aiding religion in violation of the Establishment Clause. On the flip side, if the government takes efforts to remove itself or distance itself from religion, this might be perceived as burdening an individual adherent's religious exercise, or perhaps even demonstrating a message of hostility to religion writ large. So this is a careful balancing act between these two important clauses. And these are the clauses that we're most concerned about when it comes to protecting religious liberty. So those are some constitutional basics. Before we get into the weeds with respect to how the government avoids violating principles of religious liberty, we also need to know and understand one other basic foundational concept, which is, what does religion mean for constitutional purposes? So the frustrating and very lawyerly truth about this particular question is that we have never gotten a clear answer from the Supreme Court in terms of how religion should be defined, and we likely never will. The reason for that is because there's a concern that if the various branches of government, including the Supreme Court or the federal judiciary, ever try to define religion, that this in itself might violate the Establishment Clause. And we can, probably intuitively all agree that we don't want the government defining religion for us. This is, for a lot of folks, a personal and spiritual decision. What we do know from the Supreme Court's jurisprudence about what religion means is that it's very broad. So there were a variety of cases in the 60s and 70s brought by conscientious objectors to the draft and the Vietnam War, in which the court had to analyze what the religious base for the objection was and whether it counted. And the court here said that when thinking about what religion means, it doesn't require strict adherence to orthodoxy, nor does it even require a belief in a supreme being. The court did offer the caveat that whatever religion means, it has to be something more than purely secular or purely political or purely philosophical beliefs. And whatever else it means, it also has to occupy a place of sort of parallel importance to a belief in a deity or deities. One other thing that the court has said is that whatever the religious belief or practice is, it has to be sincerely held to trigger a free exercise claim. That said, this is a relatively toothless requirement because it's difficult to prove that a person's religious belief isn't sincerely held, especially since the Supreme Court has said that religious liberty isn't limited to beliefs that are shared by all members of the particular religious sect. So these can be idiosyncratic. So it's hard to disprove sincerity when the court protects all kinds of beliefs that stray from dominant teachings. So the takeaway from all of this is that what counts as religion for purposes of protection under the First Amendment is very broad and often idiosyncratic, which is probably a good thing. So with those foundational concepts in mind, the next part of my comments today move to the more important question. So when does the government unconstitutionally violate a person's religious liberty under the Free Exercise Clause? And this is where things start to get a little bit interesting. So in short, the answer has changed quite a bit over the years, depending upon the Supreme Court's ideological makeup. In the 1960s, the Supreme Court was very liberal. This was the Warren Court era. This was the era in which the court was aggressively dismantling Jim Crow segregation, protecting individual rights in a variety of contexts, and religious liberty fell into that as well. So the major case on religious liberty from this era is called Sherbert versus Werner. It was decided in 1963. And this case dealt with a member of the Seventh-day Adventist Church who was fired by her government employer because she wouldn't work on Saturday, which was the Sabbath day for her faith. She then filed for unemployment benefits with the state of South Carolina, but she was denied because South Carolina's unemployment law viewed her as being fired for cause, and it also viewed her as failing to accept suitable work. So in reviewing her claim that being fired by the government and then being denied unemployment benefits by the government violated her religious freedom, since she was fired because she didn't work on the Sabbath, the Supreme Court articulated a test going forward to evaluate free exercise claims. So this is where we start to get into constitutional doctrine, and I'm going to try to break this down into palatable points. The test here is known as strict scrutiny, and you'll hear this phrase a variety of times this morning. What the court said in Sherbert versus Werner is that when the government either substantially burdens an individual's religious exercise or discriminates against religion, then strict scrutiny is the test for evaluating that action. And what strict scrutiny means is that the government has the burden of proof to show that it has a compelling interest at stake, and it also has to prove that the action it took was narrowly tailored to achieving that interest. So this is the most difficult standard of judicial review for the government to satisfy. Typically, that the conventional wisdom is that if strict scrutiny is the test, the government loses. It's not always the case, but it's a good rule of thumb. Under strict scrutiny, we're concerned about two primary things. We want to know how strong is the government's interest, and we're curious about the means that the government used to achieve that interest. For strict scrutiny, the government has to have a compelling interest. And when the court says compelling, it truly means compelling. So this isn't something like administrative convenience or reducing costs or bolstering efficiency. But what a compelling interest does mean is something like protecting public health or protecting children or protecting people who are vulnerable. And courts over the years have identified a variety of governmental interests that count as compelling. And then in terms of the means that the government uses to achieve its interests, so in other words, the way that the government goes about getting at its goal, for strict scrutiny, we are looking for a very close fit between the law at issue or the governmental action at issue and that asserted compelling interest. What we essentially want to know is this the only way the government could have achieved its goal? Is there anything else the government could have done? So after Sherbert was decided, strict scrutiny became the test to evaluate religious liberty claims in two distinct situations. One of these situations is controversial, and one is not so controversial, at least until recently. So taking the relatively uncontroversial scenario first, strict scrutiny applies when the government discriminates against religion. So in religious discrimination cases, the government has targeted religion for unfavorable treatment. Either the government has explicitly kind of treated religion worse than secularism in plain language in the law or governmental action at issue. So in other words, it's express. Or there's evidence that the government intended to treat religion worse, and the official public declaration for why the government acted is just pretext for that religious animus. So for example, if a law by its very terms treats people who practice Islam unfavorably for whatever reason, strict scrutiny applies. the government must have a compelling interest at stake for targeting Islam, and the government must prove that it cannot achieve its interest through any less discriminatory means. This is going to be very difficult for the government to prove, given that it's hard to see what the compelling governmental interest might be for targeting or singling out one religious group for unfavorable treatment. In the Islam example, you can imagine that the government might be motivated by stereotypes or bias. And stereotypes and bias are not compelling reasons for governmental actions. So I call this scenario the uncontroversial scenario because for a long time it was. Of course, the government shouldn't be heavily scrutinized, or the government shouldn't be targeting religion in a hostile way without being heavily scrutinized and having to back up and explain why it's targeting this religion in this negative way. This looks a lot like religious persecution. And it's a big reason for why the framers included these religion clauses in the First Amendment to begin with, to avoid religious persecution. The reason that it's a little bit more controversial now is because in the past month, the concept of religious discrimination has become more expansive than what we previously understood it to be. So we'll come back to that more towards the end of my remarks today. The second context in which strict scrutiny applied after Sherbert is the more controversial example. So in this context, the government has not targeted religion for unfavorable treatment. Instead, the reason that the person is bringing the religious liberty claim is because there is a religiously neutral law. It is generally applicable to the public at large. It applies to everyone, but that individual claims that the neutral, generally applicable law substantially burdens their religious exercise or practice. And what they want is an accommodation or an exemption from this neutral, generally applicable law. So if the religiously neutral law has in fact substantially burdened the individual's religious practices, which on this point, courts are very deferential to claims that a law has burdened their religious beliefs, then strict scrutiny applies under Sherbert. And what that means is the government has to show that granting the exemption or granting the accommodation wouldn't seriously undermine its compelling interests. So this rule from Sherbert, the second aspect of when strict scrutiny applies, was highly controversial because it was perceived as offering or providing special treatment for religion and granting individuals the ability to opt out of laws that they just simply didn't like. So a contemporary example for where this context might arise deals with anti-discrimination law, particularly anti-discrimination law that protects people on the basis of sexual orientation or gender identity. So you might have heard of Masterpiece Cake Shop. This was a famous case out of Colorado a few years ago. It dealt with a religious baker who believed that homosexuality is sinful and that same-sex marriage is sinful. And he didn't want to bake a wedding cake for the same-sex couple. But Colorado had an anti-discrimination law that prohibited discrimination on the basis of sexual orientation. So should that baker, as a matter of constitutional law, be entitled to a religious exemption? Theoretically, the answer used to be yes, or at least the baker could make the argument, at least until 1990, which is when the Supreme Court decided its famous Smith decision. So this brings me to my third part of my remarks today. So what has the state of religious liberty looked like since 1990? So Smith, this is a famous case. This dealt with a religious liberty claim brought by two men who attended a Native American church, and they both ingested peyote for sacramental purposes as part of their religious exercise. And as a result, these two men were fired from their jobs at a drug rehabilitation organization because possession and use of peyote was criminal under Oregon's Controlled Substances Act. So they were fired, they applied for unemployment benefits. That sounds a lot like Sherbert so far, but they were denied because they had been fired for work-related misconduct and therefore they were not entitled to unemployment under Oregon law. in this case, there's no evidence that Oregon targeted a religious minority for unfavorable treatment. So this isn't a religious discrimination case. Instead, these two men brought a free exercise claim under that second scenario that Sherbert had articulated, that Oregon's treatment of their peyote use and the denial of unemployment benefits substantially burdened their religious practice, specifically ingesting peyote as part of their sacrament. Justice Scalia wrote the majority opinion in Smith, and I'm not sure how many folks are familiar with Justice Scalia, but he was probably at the time the Supreme Court's most conservative justice, and he was also a devout Catholic. Yet the political winds in 1990 were much different than they are today, especially in terms of religious liberty, and conservative jurisprudence likewise looked a lot different. And I think part of this is due to sort of a nascent fear that religious conservatives might have had, that exemptions to religiously neutral laws or accommodations from them ended up favoring religious minorities at the expense of more mainstream religions. And so when we think about minority rights at the Supreme Court, the conservative bloc of the Supreme Court hasn't always been the most receptive to minority rights claims. So I think this is a bit evident in how Smith came out. So the court rejected the two men's religious liberty claim brought under the Free Exercise Clause. Justice Scalia wrote the opinion. He said, quote, "To make an individual's obligation to obey such a law contingent upon the law's coincidence with his religious beliefs, except where the state's interest is compelling, is permitting him by virtue of his beliefs to become a law unto himself." And Scalia also concluded in the opinion that this would lead to anarchy. How can the government survive if everyone gets a carve out to laws that conflict with their religious practices? And so this became the law on religious liberty under the Free Exercise Clause in the Constitution since 1990 until today. So strict scrutiny still applies if the government discriminates against religious practices or beliefs by treating them unfavorably. But the Free Exercise Clause no longer provides a claim at all, simply because a religiously neutral law that applies to everyone burdens your religious practice. So that part of Sherbert was essentially overruled. The backlash to Smith was pretty intense and pretty fast. Civil rights advocates saw Smith as kind of a reactionary response to cultural and religious pluralism, and they accused the Supreme Court of overruling Sherbert due to insensitivity and even outright hostility to minority religious rights. Congress agreed and responded by passing a federal law designed to reinstate the Sherbert standard known as the Religious Freedom Restoration Act of 1993. But for complicated states' rights reasons, the Supreme Court struck part of that law down, so it doesn't apply to states anymore. But then in turn, states kind of picked up the mantle on their own, and 21 states enacted their own Religious Freedom Restoration Acts, kind of in the name of protecting minority rights. But what these laws did was essentially revive that type of claim, where you have a neutral law that burdens your religious belief. It doesn't target you, but it burdens you, and so strict scrutiny becomes the test. In the decades since Smith, the political winds have changed again on religious liberty. And now I think it's fair to say that by and large, even religious conservative folks pretty strongly favor that Sherbert standard. So providing for a free exercise claim in the event of a burden on religious exercise. So religious rights advocates have been kind of more aggressively arguing for exemptions to a host of religiously neutral laws that purportedly burden their religious practice. So I mentioned this before, but the primary example here deals with anti-discrimination law that protect people on the basis of sexual orientation or gender identity. A lot of these disputes also deal with issues around healthcare, so contraception, abortion-related services, etc. As claims of religious liberty have shifted from a politically liberal value to an increasingly conservative one. Oh, I'm sorry. Can we Can we mute other folks too?
From name unavailable.
All right. Thank you. So as the political winds have shifted and the claims for religious liberty have been more sort of resonating in conservative legal movements, the Supreme Court itself has also shifted. So the evidence is mounting that the Supreme Court is preparing to breathe quite a lot of new life into broad-based religious liberty claims. So how might it go about doing this? One possible route that the Supreme Court might take is to overrule Smith, to say that it was wrongly decided, so that the peyote case that we just discussed. In fact, when President Trump nominated Amy Coney Barrett to the Supreme Court, his third nominee to the Supreme Court, religion kind of became a central issue around what her jurisprudence might look like. And Amy Coney Barrett herself is a devout Catholic and is involved with a somewhat controversial religious organization known as the People of Praise. And her past writings as both a professor and an appellate court judge pretty strongly suggest that she is sympathetic to broad-based claims of religious liberty, so reviving the substantial burden test. And just this term, the court heard oral arguments in a case that could be the vehicle for overturning Smith. And Amy Coney Barrett was seated on the court at the time the court heard this case. So this case is called Fulton versus City of Philadelphia. And it's a case about whether a private, religiously affiliated foster care agency can refuse to place children with same-sex parents in violation of an anti-discrimination law. And the justices heard oral arguments on this and seemed pretty divided over whether or not to grant the foster agency an exemption from the anti-discrimination law. So we are expecting a decision this spring in that case, and that will tell us a lot about what the fate of Smith is. Is it gone, or does it survive another day? Another possible route for how the court might sort of breathe new life into religious liberty claims is to reconceptualize what religious discrimination means. And this brings me to the final part of my talk for today, which involves governmental actions designed to combat the spread of COVID. So I mentioned before that religious discrimination claims have largely been non-controversial. Of course, we don't want the government to discriminate against religion. What makes it a bit more tricky now is how the court is conceptualizing discrimination. So on Thanksgiving Eve, so just last month, the Supreme Court issued a decision in Roman Catholic Diocese of Brooklyn versus Cuomo. And this case dealt with a complicated set of New York state rules designed to prevent the spread of COVID. And New York had classified areas with an elevated risk of coronavirus transmission as either yellow, orange, or red. And houses of worship in orange zones could only admit a maximum of 25 people, while houses of worship in red zones could only admit up to 10 people. So Amy Coney Barrett is now on the court. She has replaced Ruth Bader Ginsburg, and it mattered. So this was a 5-4 decision that struck down New York's rules on limitations on in-person religious gatherings as unconstitutional under the Free Exercise Clause. Why? The court reasoned that the headcount limits on houses of worship were religious discrimination. The court held that New York had targeted religious institutions because they treated them less favorably than other kinds of businesses and organizations. So the court explained, I'm going to quote a little bit, quote, in a red zone, while a synagogue or church may not admit more than 10 persons, businesses categorized as essential may admit as many people as they wish. This disparate treatment is even more striking in an orange zone. While attendance at houses of worship is limited to 25 persons, even non-essential businesses may decide for themselves how many persons to admit. So the court found that this was religious discrimination. This was targeting religion. And so strict scrutiny applies. And the court said this of strict scrutiny. So stemming the spread of COVID-19 is unquestionably a compelling interest. So that part of the strict scrutiny test is satisfied. And in future cases going forward regarding challenges to COVID-related restrictions, the government won't have a problem proving that it has a compelling interest in preventing or slowing the spread. The court goes on. But it is hard to see how the challenged regulations can be regarded as narrowly tailored. So this is that other part of strict scrutiny where we're looking at the means. How close is the fit between what the government has done and what it's trying to achieve? So the court says there are far more, these restrictions are far more restrictive than any COVID-related regulations that have previously come before the court, much tighter than those adopted by many other jurisdictions hard hit by the pandemic, and far more severe than has been shown to be required to prevent the spread of the virus at the applicant's services. And the court went on to say that there just wasn't enough evidence here that houses of worship in particular were any more likely to spread COVID or create a great risk than other kinds of businesses in these red and orange zones that could admit more people. In the 3 weeks following this decision, the Supreme Court has issued additional rulings siding with religious institutions under the same rationale. So in California, in Colorado, in New Jersey, religious institutions have sought basically exemptions to COVID-related restrictions on in-person gatherings, and the court has sided with the religious institutions, largely kicking the cases back down to lower courts for a further evidentiary finding, but granting the injunction in the meantime because the court finds that these religious institutions are likely to succeed on their claims. What seems new to me about these cases is how the court understands religious neutrality on the one hand and religious discrimination on the other. Prior to Amy Coney Barrett's elevation to the Supreme Court, the justices had dismissed similar lawsuits earlier this year, also in 5-4 opinions. But this time, Ruth Bader Ginsburg was on the court. So the 5-4 block was the liberals plus Justice Roberts. And they dismissed them presumably under the rationale that these limitations on gatherings were religiously neutral in the sense that they didn't target or single out religious institutions for unfavorable treatment. Religious institutions were just one among many types of organizations and entities that were subject to limitations on in-person gatherings. Now, with Amy Coney Barrett on the court, it seems that any governmental effort to include religious entities among different risk categories will amount to targeting. Under the theory that if any entity is treated more leniently or more favorably than religious institutions or entities, including those deemed essential, that this amounts to religious discrimination, which will trigger the most searching form of judicial review that is hardest for the government to satisfy, strict scrutiny. So rather than taking the government's word for it, when it says that indoor religious gatherings pose a unique health risk, perhaps because of singing or prolonged contact with persons with whom folks aren't related, the judicial system will now require the government to prove with laser-like precision that the risks posed by religious institutions for in-person gatherings are real. We're not going to take the government's word for it. You have to show that this restriction is narrowly tailored. And I don't have an opinion necessarily on whether this is a welcome or worrying shift from the court. I just note that it's different. And it seems to represent a Supreme Court that is highly focused on protecting religious liberty from a variety of governmental actions that in the past might have seemed benign. And so from now on, the government needs convincing empirical evidence, essentially, to justify any differential treatment of religions. If it's going to put religious institutions into one zone, but other kinds of institutions into a different zone, then the government better have evidence for why. And this means that courts are now kind of effectively in the business of overseeing public health measures, if those measures include religious entities. Where the court goes on this newly invigorated journey to protect religious freedom and liberty, I think is still very much an open question. And there's a lot we don't know yet. A lot of these decisions that the court has issued in the past month were very short, a couple of sentences, unsigned. So I get the sense that the justices are still sort of wrangling amongst themselves to figure out what their coherent theory or philosophy is going to be going forward. But I think that these early cases, including the Roman Catholic Diocese case, offer some early clues. And so with that, I think I will stop sharing my screen if I can figure out how. And we can open it up.
Wonderful. Luke, thank you so much for giving us not only the historical context, but the arguments and the rationale for the decisions, and just some key concepts that we need to understand in order to make sense of this very, very timely issue. We have solicited a number of questions from our faith leaders in San Francisco that I would like to, unedited, put to you for your response.
Sure.
The first, and we'll read them in alphabetical order. The first comes from PJ Sharon, who is a member of the San Francisco Interfaith Council Board, a congregant at Mission Minyan, and the Associate Vice President of Northwest at Birthright Israel Foundation. And I don't think he'd mind me saying this, but he was trained as a lawyer. So, you're peer-to-peer on this.
Peer-to-peer.
There are actually two questions, and let's begin with the first.
Okay.
All our traditions have encountered public health emergencies before, and clergy have always found ways to respect human life, prioritize our responsibilities to our neighbors, and encourage people to keep the faith at home. During the 1918 flu pandemic and other crises throughout history, clergy widely understood that the right religious answer was to close their doors to communal worship. Do you see significant differences between respect for human life and our obligations now? When do human health and safety concerns override religious concerns? What messages can clergy communicate that let people know that it's okay to pivot and suspend certain practices during COVID-19?
So my caveat before I answer is that I'm not a theologian and I'm very heavily steeped in law. So I think some of the questions call for a bit more spiritual response in terms of what religious leaders tell congregants or adherents. In terms of the law, I think that the question is onto something. No, I don't think that what the Supreme Court's cases stand for is that religious freedom always wins or that individual liberty always triumphs over the public good. I think what the court is saying is that, the government needs to tread very carefully. And because of the long history in the United States of discrimination against religious minorities or hostility towards certain kinds of religious beliefs, the court is very suspicious and very skeptical when the government acts in ways that burdens or discriminates against religion. So that's why we have this strict scrutiny test. It doesn't mean that individual liberty always wins. As the court said in Roman Catholic Diocese, there is a compelling governmental interest in preventing the spread of COVID. It's just a matter of how the government deals with it. So I think that going forward, it's going to be harder for the government to separate and isolate religious institutions from other kinds of entities. I think the government needs to be more across the board, maybe just in-person limits depending on the size or the space of the room, or something that doesn't specifically separate religion out from other secular institutions, because that might be a more narrowly tailored way of protecting the government's interest here.
You spent a lot of time talking about the Smith case. Let's come back to it now because there's some nuanced questions here. The 1990 peyote case, Smith, says that the state's interest in prohibition needs to be sufficiently compelling to outweigh a free exercise claim. But the facts of ritual peyote use are quite different than a pandemic. The harm of peyote happens to individuals who choose to smoke it, while a pandemic is highly contagious, involuntary, and deadly. If a prohibition on free exercise is temporary, proven to mitigate widespread sickness and death, and not intended to suppress free speech, shouldn't the government have wide latitude to determine the optimal formulation of closures, capacities, and restrictions, even in a house of worship where people sing, is treated more severely than a grocery store where people shop? And how should Harvest Rock Church, First Newsom, Governor of California, inform our state and local government officials when they draft future orders?
There's a lot in there, so let me see if I can remember most of it. On the first point about the ingestion, taking peyote and it being more of a private harm than a public harm, I think there's some truth to that. From the Supreme Court's perspective, and there are a variety of cases that the court has decided dealing with marijuana and other illicit substances where the court doesn't conceive of the harm that way. We can agree or disagree, but the court stance on this is that the ingestion of drugs or the possession of controlled substances or the distribution of controlled substances is more than just a personal harm. It's a societal harm because it leads to social ills and the variety of sort of the war on drugs talking points. So I don't know. I think that's a theoretically sound argument that this is a different kind of harm, but I'm not sure that the court would conceptualize it that way, is my response to that, I suppose. Second, shouldn't the government have more leeway here because of the kind of public health, the very undeniable public health consequences? My gut is yes, but I'm not on the court. And I think to the extent that I don't have a strong opinion yet on what the court's kind of renewed push for religious liberty protection means, I do have an initial concern, which is that I'm not sure that characterizing every governmental action that isolates or separates religious institutions, especially among other institutions, necessarily means that it's discrimination. So I think that might be where I depart from the court, because once the court made that move, then the government no longer has leeway. So we can't just trust the government. The government has to prove every single instance of why it's treating religion in this particular way. So I think that is a consequence of these latest decisions. And I think for Gavin Newsom or mayors, you have to be more general. I think after these latest cases from the court, no longer can government officials say, well, religious institutions are in this tier while essential businesses are in this, and there's a difference in how many people can attend and do what. I think it has to be more general.
The next question is from His Excellency Most Reverend Salvatore Cordileone, Archbishop of the Archdiocese of San Francisco. And he asks, when, and if ever to what extent, can injunctive relief given to a plaintiff in a lawsuit be applied to others who are in the same or very similar circumstances, but are not a party in the case?
That is a hotly debated legal question. It's a good law review article. There are a lot of questions about universal injunctions right now, whether a lot of federal judges issue them. So you bring in a constitutional claim, and I can think of a lot of Trump administration policies, for example, rolling back DACA or aspects of the border control where judges issued universal injunctions. So no matter who is affected by this, the government is prevented from acting in a way that would harm that person, even if they weren't a party to a lawsuit. And these are controversial, and the Supreme Court hasn't decided yet on whether or not it's permissible for a judge to craft an injunction this broadly, but they are doing it. So federal judges are already in this business until the Supreme Court tells them otherwise.
Okay. The next question is from Reverend Elizabeth Eckdale, lead pastor at St. Mark's Lutheran Church. And she asks, how does the right to worship differ from other rights? For instance, travel and assembly being limited by government orders during the pandemic?
That's a good question. I don't think that the right of assembly is necessarily different from the right of worship. When the court discusses free exercise under the First Amendment, it kind of lumps the two together, that assembly and exercise are sort of synonymous. The right of travel is different. So there is a constitutionally protected right of travel, but it comes from a different constitutional source. So for religious liberty claims, those stem from the First Amendment. Right of travel claims stem from actually a couple of different places, but one is the Privileges and Immunities Clause, which stands for the idea that no state shall sort of discriminate against out-of-staters with respect to certain fundamental rights, including the right to travel. why that's different, or why that matters in terms of where these rights come from, is that the current Supreme Court is extremely invested in the First Amendment. Um, I wrote an article this summer kind of examining what the court is doing with respect to the First Amendment, and there's very much sort of a First Amendment libertarianism alive in the court, which kind of is a hands-off approach. So a more robust vision of free speech, a more robust vision of free exercise. And so I think it's harder then for the government to regulate speech or religion in ways that perhaps it used to. Whereas the things like the right to travel that come from these other constitutional provisions, sometimes they get lesser scrutiny. So there are some cases where the court applies what's known as intermediate scrutiny, which is a more kind of elastic standard, which gives the government more leeway to do what it wants in terms of impeding on the right to travel. And in part also the court just isn't as invested doctrinally or ideologically in those particular kinds of claims. So I think that to the extent that the government has infringed on some of those other kinds of rights, it presents less of an urgent problem for the court than the First Amendment claims do.
I would advise you to answer the next question with the greatest of care, because it was posed by your boss, Father Paul Fitzgerald, the president of the University of San Francisco.
I'll do my best.
How can faith leaders help their congregants understand their share of responsibility in this public health crisis and therefore not claim a religious exemption from vaccination?
That is also hard, and I feel like it calls for more of a spiritual answer than a legal one. I will say a couple of things. From the law side, I'm legally trained. There's an interesting case from 1905 called Jacobson versus Massachusetts, which dealt with a compulsory vaccination law, and which is very relevant today, where the Supreme Court said that whatever one individual's fundamental rights are, they can't be so broad as to harm others. This was a court from a very different time, but the idea being, if it's for the greater good, then the government can require individuals to be vaccinated. Your rights don't sort of trump societal interests. And there are some other cases where the court has made similar overtures, about the right to control the upbringing of one's child. The court has said, yes, that that's a fundamental right that we all have, but it has to be exercised with caution. You can't raise your children in a way that harms others. And again, some of these cases are also about vaccinating your kids. Can you get a religious exemption from a mandatory vaccination law that requires you to do so before you send your kids to school? And courts, by and large, have rejected claims like that under this idea of the greater good or protecting the commons. And so I think some of those legal ideas that even a very conservative federal judiciary has espoused, I hope are appealing to congregants. I think that one of the challenges is that we as a culture are more perhaps libertarian and identitarian and sort of self-focused than perhaps we were in the past. There's something really intoxicating about sort of individual liberty and individual freedom. And I think we saw a lot of that this spring in these raucous rallies against mask wearing and social distancing, and I think it's a bit cultural that we've ingrained this idea that the self should come before the greater good, and so I don't know. I think that's where this kind of verges on spiritual for me. It's a hard question.
I'm sure that you can follow up on that in person with Paul,
Sure.
and let us know how that goes. Okay. The next question is from His Eminence Metropolitan Gerasimos of the Greek Orthodox metropolis of San Francisco. Is a pandemic and the attempt to curb further spread legal justification and enough of a case by a state or local government for a compelling reason to infringe upon our basic constitutional right of free exercise? I have in mind the Supreme Court ruling on Tuesday in favor of the Colorado church that was challenging capacity limits.
Yes, so this is an easier one to answer. The Supreme Court has answered part of it. So in Roman Catholic diocese, the court said yes, controlling the spread of COVID and mitigating the effects of the pandemic, those are compelling interests. Where the legal question arises then is, well, what counts as an infringement? So it's not correct to say that any regulation on religious institutions per se is an infringement. Whether or not that governmental action counts as an infringement depends then on the strength of the government's interest, which we know now is compelling, and how the government goes about achieving it. So as long as, and this goes back to an earlier answer I gave, as long as governmental officials are more general and more neutral in terms of how they are designating risk, and how they are sort of separating out religious versus secular institutions, which they probably can't now. As long as the government is doing that, then likely it wouldn't count as an infringement of free exercise. So that's where the means matter.
Can I just ask as a follow-up to that?
Yeah.
What's the difference between infringing upon and violating constitutional liberties? I mean, how does this difference apply to the present cases of limiting worship during times of pandemic?
I use them interchangeably, which maybe some professors might bristle at. I think a violation means, yes, there has been an infringement. I think some people use the word infringement as any kind of burden on the asserted right, which isn't necessarily true in terms of when the Constitution is violated. Let me give you an example. So there's a famous case on marriage. We know that marriage is a fundamental right, and Wisconsin passed a law that required people who wanted to be married to confirm that they had satisfied all outstanding child support obligations. So this wasn't an outright prohibition on the ability for individuals to get married, but it was a burden. And so the Supreme Court in that case said it's a substantial enough burden to then trigger strict scrutiny, and then based on the analysis of strict scrutiny, that's why there was an infringement on the right. So I think this is probably too technical an answer for what you were looking for, but that's how I understand it.
The next question comes from Reverend Marcy Glass, the pastor and head of staff at Calvary Presbyterian Church. She says, I don't see curtailing public worship in the cause of public health as a threat to religious freedom unless they are curtailing a particular group while allowing others to practice. My bigger question is, how can faith leaders be public faces of support for public health leaders? That may not be pertinent to the presentation, I realize, and the current trajectory of religious freedom decisions is at odds with a historic Presbyterian understanding of the term.
So I think part of the question calls for a spiritual answer, and then the first part of the question, I think, is again kind of where we're seeing something new. I think the commenter kind of expressed incredulity or disagreement with the proposition that any regulation of a religious institution in the time of COVID counts as discrimination, whereas opposed, what she would be looking for is targeting one particular religious group. I think that that's where the difference is. I think we previously understood religious discrimination to be hostility towards one religious group or practice, whereas now the court seems to be saying that anytime religion writ large is separated out, that equals discrimination. So I understand the source of her disagreement, and I think the answer is forthcoming. I think this is more of what we're going to get from the court.
The next question comes from Hala Hijazi, a member of the San Francisco Interfaith Council Board of Directors, but also a commissioner on the San Francisco Human Rights Commission. She says, in the 90s, the activism and collaboration between religious and civil liberties organizations was effective, especially in their advocacy to restore the compelling interest test. With today's political environment and changes on the Supreme Court, will this increase and energize new collaborations, and how will the Supreme Court deal with California's district court refusal to follow its direction after recently granting an injunction for churches and synagogues in New York?
Can you repeat the second part of the question, just so I'm clear?
Sure.
About the refusal to comply.
Yes. Yes, it says, with today's political environment and changes on the Supreme Court, will this increase and energize new collaborations? And how will the Supreme Court deal with California's district court refusal to follow its direction after recently granting an injunction for churches and synagogues in New York?
I think I would want to know a little bit more about what the questioner means by the district court's refusal. From my understanding, the way that the Supreme Court has been dealing with a lot of these cases is to remand them back to lower courts for further fact finding. So I'm not sure I'm not sure that the district court has disregarded the Supreme Court's ruling yet. The court is granting injunctions, so they're preliminary injunctions, but that's so that these cases can go back to lower courts for more evidentiary hearings. And I assume that's what the district court will do, unless I'm woefully mistaken or I've missed some developments. On the first part of the question, I don't want to put words in the commenter's mouth, but I think that this is kind of what I meant when I sort of discussed how the political winds have shifted on religious liberty. Whereas in the 90s, religious liberty claims were, really a liberal cause, because folks were sort of outraged at Smith and the disregard for minority religious rights. Whereas today, religious liberty claims are more often sort of heralded by folks that are, I don't know if that's an appropriate way to phrase that, but it's been embraced pretty heartedly by the conservative legal movement. And so I think that's in part, I don't think that with the court as it's currently comprised, which is more ideologically conservative than it is liberal, I'm not sure that the claims for minority religious rights were resonating that much. But I do think that sort of this concern about chipping away at the status quo by instituting sort of cultural and social change in a way that's counterintuitive to traditional religious teachings is scary to the conservative court. And so I think that that's what's resonating right now. I think that that's why, more than anything else, the Sherbert kind of undue burden standard might be resurrected, which is perhaps a cynical take, but it seems to be where things are heading.
We have three more questions. The first comes from Mark Holmrud, the Bishop of the Sierra Pacific Evangelical Lutheran Church in America. Isn't there a burden on houses of worship to provide for the well-being of the most vulnerable among us? In other words, should not houses of worship, faith communities, be held to a different standard of care for constituents than other public establishments which have less restrictive requirements for gathering?
I think that calls for more of a spiritual or moral answer. As somebody who grew up attending Methodist services and being a church camp counselor, I tend to agree that perhaps there should be sort of a spiritual greater standard of care, or at least that's how I was raised. But I think, legally speaking, we know for sure that the government can't dictate the internal functioning of churches. So there's a sort of ministerial exception where it's essentially hands off. The government cannot tell what church personnel to do or say or even hire. So legally, the answer would be no, but spiritually, the answer, I think, depends. And for me, it's yes.
A higher calling. The next question comes from the Reverend Anna Rossi, Successor at Grace Cathedral. When the climate around public health restrictions on religious gatherings became more litigious, the San Francisco Department of Public Health continued to counsel religious leaders by embedding stricter recommendations within the more permissive health orders. How could the most recent SCOTUS decisions impact the ability or willingness of local health departments to publish their recommendations specific to houses of worship, especially in directives?
I think that the recent Supreme Court decisions are a huge red warning flag to local officials. Proceed with caution. If you are going to make specific recommendations for houses of worship, this is dangerous territory now, because that's evidence that the government has targeted and separated out religion from non-religious entities, which under these three most recent cases would trigger the most difficult standard of review for the government to survive. So I think that, I missaid this a couple of times, I think the government will likely begin to issue more general recommendations. Alternatively, strict scrutiny isn't always fatal. So if California or a local official feels strongly that religious institutions pose a unique threat, then those officials need to compile evidence. Narrow tailoring under strict scrutiny requires that the government prove it. So where's the empirical evidence? What studies have you relied on? What are health professionals saying? It can't just be because we think so, or this is our gut feeling. So those are the two routes: prove it or be more general.
The final question comes from Rabbi Jonathan Singer, Senior Rabbi at Congregation Emmanuel. How does the court deal with internal disagreements within denominations? If, for example, ultra-Orthodox Jews who challenge being forced to make a wedding cake for a lesbian wedding versus Reform Jews who assert that gay marriage must be recognized, each speaking from their own understanding of Judaism.
Yeah, this goes to the first part of my talk today, my prepared remarks today, which is what counts as religion for constitutional purposes. And the court has said it has to be broad, it's idiosyncratic, it doesn't have to adhere to mainstream orthodoxy or teaching. To the extent that there are denominational splits, that's fine. What the religion clauses protect is individual religious beliefs. So you can have competing religious claims serving as different bases or the same basis for a religious discrimination claim. That's how broad religion is under these clauses.
Luke, I want to thank you. We've done this series, and in fact, I think this is our 33rd program. I don't think any one particular program has hit home so closely than this one. I suspect that once we send out the recording link, it will be listened to by not only our faith leaders, but by their governing bodies and their legal counsel. You have provided important context and resources, and we are appreciative to you and to University of San Francisco Law School. So thank you. And
Thank you.
we're saying,
thank you very much for having me.
And as we're saying thank yous, I also want to express thank you to SFIC Administrative Program Associate Cynthia Zambucas, as well as to the COVID Command Center's Joint Information Center Virtual Outreach Team. I know our overall coordinator is here with us, John McKnight, our producer, Alisa Karawali, and Sharon Walton, who is our lead, and Hafisa Salabai. We're going to be taking a brief hiatus until after the holidays and New Year, and we'll resume programming on January 7th, when we'll welcome some visionary volunteers in neighboring Eden Interfaith Council who are producing and distributing PPE masks to vulnerable populations in the East Bay. And we're welcoming them with the hope that we can replicate their incredible example here in San Francisco. So that concludes today's program. Once again, thank you to Luke, and thank you to all who attended today. God bless you.
Thank you.